Good evening, everyone. Welcome to this evening's program, the 2022 Employment Law End Year Review. I'm Lorena Vazquez, and I have the honor of moderating tonight's program. You should have received program materials via email yesterday. If you did not, they are going to be placed in the chat. You may download them there. After the completion of the program, you will receive your MCLE certificate via email. There's a question and answer feature where you may post questions, and our presenters will do our best to answer those questions. I will now introduce our presenters. We have here Andrew Friedman, partner at Helmer Friedman. Andrew is a plaintiff's attorney who represents employees in all aspects of employment law. He has handled a wide range of employment-related litigation in both state and federal court. He has recovered millions for his clients and is also the author of Litigating Employment Discrimination Cases. I have a copy myself. I find it extremely useful, and I highly recommend you get yourself a copy. Also joining us is, yes, there it is, Tony Oncidi, partner at Proskauer, defense attorney and co-chair of the Labor and Employment Department and head of the West Coast Labor and Employment Group here in Los Angeles. Tony represents employers and managers in all aspects of labor and employment issues. A substantial portion of Tony's practice is defending employers in large class actions, employment discrimination, and wrongful termination litigation in both state and federal court. Tony is also the author of a treatise entitled Employment Discrimination Depositions and co-author of Proskauer's on Privacy. Now we'll begin our program. Welcome, Tony and Andrew. The floor is yours.
Thank you, Lorena. Good evening, everybody. Thank you for joining Andrew and me tonight. I think the Beverly Hills Bar Association is one of the longest tenured runs that Andrew and I have had in doing these yearly updates, which we really like doing. And we have the opportunity to speak with you tonight about all kinds of new developments. It's one of the greatest things about being an employment litigator, whether you're on the defense side or the plaintiff side. There's always a new statute, there's always a new regulation, there's always a new case. We run a very active blog in our office here in Los Angeles at Proskauer. And, we have a revolving blog duty for our various attorneys in the group. And there's almost never a question as to, do we have anything to write about this week? Because there's always something new to write about. And we get to speak to you about it tonight. We're really happy to be here. We're going to start with litigation. I'm sorry, we're going to be starting with legislation, and then we'll talk about cases after we go through the legislation. One of the things that's a little bit different this year is there's quite a bit of federal legislation that affects employers, not only in California, but around the country. And we'll walk through that for you. And this is the first statute that we wanted to talk about. This is the the law ending mandatory arbitration of sexual assault and sexual harassment claims. So those of you who are familiar with employment litigation and the way in which it overlaps with arbitration know that up to this point, almost all of the legislative activity in this area occurred at the state level. And many states are really quite hostile to arbitration, have been for a very, very long time. California is no exception to that. This is the first time since, I believe, the Federal Arbitration Act was originally passed 100 years ago or so, where the federal government has now taken away some of the broad right to arbitration that employers that engage in interstate commerce were able to access. And what they have done with this Ending Forced Arbitration Act is making cases and claims that arise under sexual assault claims and theories and sexual harassment claims and theories exempt from arbitration. So this is a direct result, of course, of the Me Too movement and the Harvey Weinstein situation that took place more than 5 years ago. And what this does essentially is it carves out a right to arbitration that would otherwise exist for employers and employees. in California and elsewhere if the claim involves sexual assault or sexual harassment. I've written a lot about this, spoken a lot about it. I have my own personal opinion about it, and one of which is that I think arbitration oftentimes can be a very efficient, cost-effective way of resolving matters. Plaintiffs' lawyers tend to disagree with this. They often will give a reason having to do with confidentiality and letting the sun shine in, all kinds of different beautiful metaphors. But in the back of their minds, I think, and I won't speak for Andrew, he can either admit it or deny it himself. Plaintiffs' lawyers and defense lawyers are aware of the fact that juries tend to be much more favorably disposed toward employees who are claiming discrimination and harassment and wrongful termination and whistleblowing than arbitrators are on the whole. And more importantly, juries tend to be much more generous in the verdicts that they award. And this is a very common pattern now. There's no question about it. We'll talk, I think if we have time later on, about the tale of two cities associated with both an arbitration and a jury trial against Tesla in Northern California. Both involved African-American employees, separate employees, different employees, but who claim very similar things had happened to them in the workplace at Tesla in Northern California, including that there were allegedly swastikas and nooses in the workplace and so on. Very obviously very horrible kinds of things. And the first case that was decided came from an arbitrator, and the award to the employee was $1 million. And everybody at the time thought, wow, that's a lot of money for an award from an arbitration. That was followed not too long thereafter, I think it was only a number of months thereafter, by a jury verdict involving a different employee, but who alleged very similar kinds of activities in the same workplace. And a San Francisco federal court jury awarded that employee $137 million, 137, as opposed to one. So it's almost a laboratory experiment of how arbitration can treat certain claims and how civil litigation can. And it's not surprising, therefore, that many employers are suspicious of jury trials sometimes, and many plaintiffs' lawyers are suspicious of arbitration. What I don't really like about this new federal law is that it really kind of takes the position implicitly that there's something wrong with arbitration by saying, gee, if you've been sexually harassed or you've been the unfortunate victim of sexual assault, you should be not consigned to an arbitrator, but you can go to a jury. What it doesn't answer is the question, well, what if you've been racially harassed? What if you've been harassed based upon a disability or your age or your whistleblower status or any number of other things that are protected under the law? Those are still claims that would be put into arbitration, presumably, and not subject to this carve out. Now, Andrew will say, Andrew, you don't really need to be here. I'll just speak for you for the rest of the
time. I can just go.
He will say, and I'm not going to present it in a cartoonish way like I typically do. You know, he'll say, yeah, you're right. All of those things should be exempt from arbitration. Let's junk the whole system. Anyway, Andrew, you can respond if you'd like.
No, you just summarized my position perfectly. Nothing to add.
Excellent. Let's go to the next statute. Or sorry, this is just a case law site that the new statute that we just talked about involving the exemption from arbitration of sexual harassment and sexual assault claims is not retroactive. And here's actually a very recent case here in the Central District of California called Dearl, D-I-E-R, Newcomb Dearl versus Amgen. And you see the site there on the screen from May of last year, decided by Judge Dolly G, a former plaintiff's lawyer, who determined that this law was not retroactive by its terms.
Wait, before we jump on, I do want to mention a brand new case that just came out yesterday called Murray versus Superior Court 2023 Westlaw 1098-156. This case from the 4th Appellate District also holds that the law is not retroactive, but the 4th Appellate District says, quote, "We regret that this new legislation does not apply retroactively, end quote. And then the Fourth Appellate District goes on to say that the arbitration agreement is unenforceable because it is procedurally and substantively unconscionable, partially because of the strict secrecy that it imposes or that it has. So check that out.
Yeah, and let me just footnote that. Be very aware when you're drafting arbitration agreements or reviewing them. Don't overreach. Try to get the best, most accurate, most up-to-date version of what is okay in California and what is not. And that's very difficult to do. I have a rough count, and I think there are probably over 150 cases, and I'm not exaggerating, appellate court cases, published appellate court cases in California, critiquing, some affirming, and permitting arbitration in various agreements. And so it's not as simple as you may think, and it's not for novices. So make sure that if you do have an arbitration regime, make sure that the agreement, I think most importantly, doesn't overreach. So we've had cases where employers, for example, ridiculously shorten the statute of limitations or limit the number of depositions that the plaintiff can take, but not that the defense can take, or say that it only applies one way or the other as to certain claims. Those are easy targets and easily shot down, and the plaintiff's lawyers will be looking for anything they can find. And many judges, by the way, will be looking for anything they can find to invalidate an arbitration agreement. So beware. This is another new statute just from December last month. This limits pre-dispute non-disclosure agreements in sexual harassment and assault situations. This does not, importantly, and this is I think the real guts of this, does not limit non-disclosure agreements in the context of a settlement agreement, because it only applies to clauses that were signed before the dispute arose. So in other words, if the employer has all applicants or all new employees sign a non-disclosure agreement, and it could affect disclosure about sexual harassment or assault, that would be invalid. This is something for those of you who are in the entertainment industry should look at and think about carefully. Many people in the entertainment industry, many production companies, many well-known celebrities have these non-disclosure agreements. So make sure that you, I think, have tested them for purposes of compliance with this law.
On December 30th of last year, the most unfairly underrated president in recent history, President Joe Biden, signed a bipartisan $1.7 trillion omnibus spending bill, which contained two important pro-employee pieces of legislation: the Pregnant Workers Fairness Act and the Providing Urgent Maternal Protections for Nursing Mothers Act, the PUMP Act. Because these federal laws basically mirror what FEHA already does, I'm not going to go into the specifics. I just wanted to point out these two new laws in case you wanted to be, for some reason, in federal court. You can sue under these two laws, or in case you're representing employees outside of California, typically in a red state that doesn't have these types of protections. Tetrahydrocannabinol, can never pronounce that word, THC, is the chemical compound in cannabis that can indicate some type of impairment or psychoactive effects on a person. Or, as Seth Rogen likes to say, it's the part of the plant that is 100% intrinsic to his functionality and his life. After THC is metabolized, it turns into a non-psychoactive metabolite that stays in your system for weeks, and it can be detected in various blood, hair, urine tests, etc. In 2008, the California Supreme Court decided the Ross versus Raging Wire case, holding that FEHA did not provide protections for individuals using cannabis. This new law, AB 2188, is designed to partially reverse the Ross versus Raging Wire case. It won't be effective until January 1st of 2024. This is to give employers time to get ready to deal with it. But effective January 1st, 2024, it will be illegal for employers to discriminate against employees because they either A, use cannabis after work hours off-site, or because they test positive for non-psychoactive cannabis in their hair, blood, urine, other bodily excrements. The employers are still allowed to fire employees who are using THC, that's the impairment part or the psychoactive part. This bill does not cover all workers. Certain workers, such as people in the construction trade, are excluded, as well as those individuals who need to get some type of federal background clearance. As climate-related disasters around the country increase, we see employers frequently forcing their employees to work in dangerous conditions through these climate disasters, just so the employers can earn a few extra bucks. So, for example, in December of 2021, in Edwardsville, Illinois, you had this Amazon warehouse where the workers alleged that they were not allowed to leave, even though a tornado was bearing down on them. They weren't allowed to use their cell phones to check on the status of their tornado, and they weren't allowed to call their loved ones or the authorities. And unfortunately, several of these workers were killed and several of them were injured. Similarly, in the Getty and Atlas Tubbs fires, you had various workers, domestic workers, caregivers, gardeners, agricultural workers, who were also forced to work through these fires, and some of them were injured and killed as well. SB 1044 was designed in part to try to force employers to do common sense things that they shouldn't need a law to require them to do. So this new law allows employees to access their cell phones at work to determine the safety situation if there is an emergency situation. Similarly, it allows employees to leave without being able to get in trouble, can't be fired or otherwise retaliated against if they reasonably believe that an emergency condition is going to adversely affect them. The term emergency condition is defined very broadly to mean a condition of disaster or extreme peril to the safety of the workers from either natural forces or criminal acts. So if a criminal bursts into your workplace with an AK-47 and your boss tells you, hey, get that memo out the door before you leave, you can leave and you can't be fired.
I'm sure that has really happened, Andrew.
It probably has, I'm pretty sure. It also protects in cases of a declaration of a emergency. Interestingly, the bill specifically excludes from the definition of emergency condition COVID or a health pandemic like COVID.
Okay, SB 189. I'm not sure why this happened, but for whatever reason, the legislature has decided to rename the august DFEH that we've known all of these many years, the Department of Fair Employment and Housing. It is now referred to as the Civil Rights Department. I have never heard anybody refer to it by that name since July of last year, including Andrew. I always forget that that's what it's called till I see this slide. So those of you who don't ever use the DFEH name, forget that you ever heard it if you've now seen it, and just call it the Civil Rights Department going forward. Also, as if that were not enough, the Fair Employment and Housing Council has been renamed the California Civil Rights Council, which, by the way, sounds a lot like the Civil Rights Department. And I would imagine that all kinds of mayhem will ensue from this renaming process. You heard it here first. SB 1162, this is pay data reports that now must be part of a pay scale disclosure. And this requires private employers with 100 or more employees to submit a pay data report to that's right, the Civil Rights Department annually. Employers of 15 or more must include the pay scale for a position. This is causing confusion already as to what the pay scales really need to look like, how they need to be done. There are a couple of other states in the US that already require this. So we're getting inquiries from clients already, and we're able to draw on the resources of some of our lawyers who've looked at this in some of the other states, but it's not maybe as easy as it seems. And I think some employers are defaulting to much broader pay scales because it's better to do that than not, or at least that's the interpretation. And I'm sure that may get slapped down by a court at some point, who knows? But at this point, I think some employers are defaulting to that so as not to be too restrictive in terms of what the pay scales might be. Of course, the broader they get, the less informative the scales are, and I think that could be a problem as well. AB 1041, leave for a designated person. So under the California Family Rights Act, there has been obviously the right previously to take leave for members of the family. What this does is it broadens the definition and allows workers to take time for a designated person, and that is defined as any individual related by blood or whose association with the employee is the equivalent of a family relationship. I don't know if there are any regs on this. I haven't seen it, and you can imagine where that could get a little bit vague as to what an employee may consider somebody to be in terms of an equivalent family relationship. There are many, many kinds of those relationships that we can all think of, and I think would probably neatly fit within this definition, but I'm not sure how broadly some employees might end up using that. The employee does not have to identify the designated person until they request the leave. So this is for assistance that the employee will be giving to this designated person, and the company is permitted to limit the workers to one designated person per 12-month period. So within that 12-month period, if there's somebody who was a designated person who you now hate, you can exclude that person and designate somebody new. Bereavement leave, AB 1949. This amends the CFRA to provide employees with up to 5 days of job protected bereavement leave. This is something that I think many employers already did do. It's an example of, I think probably a law that maybe some employers really needed to have, but most employers I think already would have provided bereavement leave for the death of a close family member. But there's never an end to the regulation of some of these things, and this is the latest. So this is now a regulated aspect of the employment relationship, which of course you should keep in mind when you are reviewing handbooks and advising clients on these kinds of issues.
In 2018, the California legislature passed a law designed to stop employers from trying to deter or discourage union membership. That law was called the Prohibition on Public Employers Deterring or Discouraging Union Membership, PED. PED applied to all public employers and, with some exceptions, provided for jurisdiction under the Public Employment Relations Board, PERB. This new bill, SB 931, provides essentially a private right of action, allowing unions to sue or to file claims with PERB, alleging that the employers have tried to deter or discourage union membership. And it allows PERB to fine employers up to $1,000 per employee deterred, up to a maximum of $100,000. And it sets forth various factors to take into account by PERB for imposing that fine. It also allows for unions to recover their attorney's fees and costs. And if PERB has to file a lawsuit, it allows for PERB to recover its attorney's fees and costs. On June 24, 2022, a day that will also live in infamy, the radical, activist, far right-wing conservatives on the Supreme Court did something that even the uber-conservative Lochner Supreme Court never did. This Trump court, in a 5-4 decision authored by Justice Alito in Dobbs versus Jackson Women's Health Organization, reversed Roe versus Wade and Planned Parenthood of Southern Pennsylvania versus Casey. In doing so, this Supreme Court took away a fundamental right for the first time in U.S. history. Perhaps most surprisingly about the Dobbs decision is that the right to choose was cavalierly stolen from the country, even though it was repeatedly reaffirmed and reaffirmed by multiple different compositions of the Supreme Court over decades. Roe had achieved what Tony's hero and Justice Antonin Scalia acolyte, Judge Michael Luttig, called super stare decisis status. Justice Thomas, in his concurrence, suggested that the court should go much further and get rid of all protections for substantive privacy concerns like birth control, etc. This bill was a direct response to that, to preclude employers from discriminating against or retaliating against employees who exercise their reproductive health care decision-making. It's a very important law. So FEHA has now been amended to expressly include protections that the U.S. Supreme Court is poised to take away.
I promise not to go after any of that red meat that Andrew just
Why it's so much fun when you do.
threw onto the ground. And Scalia, although was my contract professor in law school, I don't know if he was my hero, but I did spend some time with him in law school. This next law is really something else. Again, this is the Fast Food Accounting and Standards Recovery Act. And I think it's known by the acronym FAST, the FAST Act. And what this does is it creates a European style works council, essentially. I've actually said that without really knowing what a works council is, so I could be totally wrong. But in my mind's eye, what a works council is kind of what this is. So you've got a 10-member council that is composed of employees, employers, and union activists to set the minimum wages and working conditions of fast food workers in the state. What could possibly go wrong? And among other things, the law permits this council to increase employee wages by a significant amount in the first year. Now it's been suspended in its application because it's going to be on the ballot, I believe, in 2024. So this is not actually happening right now. But what this would have done, and I don't have the actual number in front of me, this would have allowed the minimum wage in fast food restaurants that are part of what's regulated here, of the part of the economy that's regulated here, to go up. I think it was something like 50 or 60%, from $15 to $23 or something like that. They had the ability to immediately raise the minimum wage to that amount for the fast food restaurants that are affected by the law. As we said here, the Sacramento Superior Court has entered a preliminary injunction, so it won't apply, if ever, certainly not before the vote, which will take place in November, I believe, of next year. The thing that's most insidious about the FAST Act, from my perspective at least, is that it doesn't apply to all fast food restaurants, as you might expect it would. It actually only applies to certain. If we were in a live setting, I'd ask people to guess, if they didn't know, which fast food restaurants it applies to and which fast food restaurants it doesn't apply to. And it's not based upon hamburgers, tacos, or pancakes. It is based upon whether they are unionized. And if, in fact, a fast food restaurant is unionized, it is exempt from being regulated by the FAST Act. Only those restaurants that have the audacity to remain union-free actually are regulated by this law. So you could have the peculiar effect, and this presumably will happen if the law doesn't get changed or permanently enjoined. You could have a unionized workplace where employees actually are making less money than the FAST Act regulated fast food franchise across the street could, I think, even be in the same system, could be McDonald's 1 and McDonald's 2. And if one is unionized and the other is not, those who are working at the unionized restaurant actually could get paid less. And obviously I said insidious, the reason this law exists is to incentivize, indeed to force fast food restaurants that are not unionized to think better about whether they wanted to continue to do business that way. You can draw your own conclusions as to who was behind this and why it sailed through the California legislature and was signed by our governor, but I'll say no more.
Thanks.
The mandatory postings and pamphlets law. So we have this, I don't know if any of you are going to work regularly, but if you are, check out all the postings that there are in your coffee room. There are now 8 of 18 of these notices that will have to be updated in 2023. They better have already been, by the way. 30 days have come and gone, and you are living at your peril if you've not updated those postings and pamphlets. I think the ironic thing about this law is that the more postings that are required, the more minuscule the type comes for each and every one of the previous postings that were also required. And I'll bet not 1 in 1,000 employees in any workplace have ever actually read any of them or even know that they're there. It's a little bit of an antiquated way of notifying people, sort of putting it up on a board. It's kind of like Martin Luther putting the tenets that Andrew believes so strongly in that kicked off the Reformation. So I don't really understand what they're doing, why they keep just insisting on more and more things being posted. Like I say, all it does is diminish the importance of all those that came before, and it's very difficult to tell which ones, if any, are really important. This reminds me, as do some of these laws, of one of my favorite quotes I used to give in these presentations from the governor of our great state prior to our current governor. That was Governor Jerry Brown, who you may recall was a governor for 16 years over two term periods of time, one in the 1970s and one in the early, well, I guess mid 2000s. He famously said, or at least famous to me, he said, "Not every human problem deserves a law." I don't think anybody in Sacramento subscribes to that point of view any longer.
Do you want to talk about the rest of these?
These are mandatory pamphlets. These have already been mandatory for a while. I don't know if every employer or even most employers actually hand them out, but they're supposed to, and or include them within at least the sexual harassment provisions within a handbook if you do have a handbook. But they've been updated as well for January of this year, but as of January of this year. And there you see it, the Civil Rights Department of California, not the Department of Fair Employment and Housing. Cases, Andrew, we've arrived at cases.
No, we have minimum wage. Really
minimum wage. Sorry, yeah.
So minimum wage for all employers, regardless of size, starting January 1st, is $15.50 an hour. This means, importantly, there's a salary basis component to determine if someone's properly exempt, which is now $64,480, unless you're a computer professional. If you're falling within that exemption, it's $112,065.20. It's important to note, however, that many cities and counties have much higher minimum wages, so keep those in mind. Okay, Tony, now we're moving into
here we are in cases. These are some of Andrew's favorite people. He's already said so many very kind things about them. And as we did with the statutes, we're going to talk first about arbitration in terms of the cases. And this was a major blockbuster that the Supreme Court has, if nothing else, an unerring sense of drama. And they always wait until the very last week or day before 4th of July, typically, to issue the biggest opinions. This was no exception. This came out on June 15th of last year, and this is the Viking River Cruises case. And this was the US Supreme Court doing something that California employers, at least for a very long period of time, were hoping and praying they would do, which was intervene into the madness that we know as PAGA, the Private Attorney General's Act here in California. There had been many, many years that had passed since this Ascanian opinion that you see before you, or that's cited here. That was the California Supreme Court case from 2014 that essentially said that PAGA claims are exempt from arbitration. So kind of like we talked about earlier, sexual harassment and sexual assault claims now under federal law are exempt from arbitration. The Ascanian court came up with a different reason. There wasn't a statute in place. What they basically said was that PAGA claims are not individual claims, essentially that employees are bringing against their employer. They are Private Attorney General Act claims. I've advocated for a while, but Andrew won't let anybody follow it. And that is that PAGA should actually be an abbreviation or an acronym for pretty much all goes to the attorneys, PAGA, pretty much all goes to the attorneys, because they get a third no matter what the employees get. And what the Ascanian case said was that because the employee is acting on behalf of the state as a private attorney general, even if the employee does agree to arbitration and signs one of those little suckers, the arbitration agreements, that does not mean that the case actually can be arbitrated, because the state, which is theoretically the motivating party here, or the active party, through the employee and more importantly the employee's lawyer, hasn't agreed to it. And so what was happening routinely was that you would file a motion to compel arbitration, because PAGA often is mixed in with a bunch of other claims. The Superior Court judge would, as a matter of course, would typically stay the PAGA action in court and then send the rest of the claims, whatever they may have been, discrimination claims or whistleblower claims or breach of contract claims, to arbitration. So then you would then have this stayed proceeding. You'd be in a situation where you go to the arbitration first, typically with all the other claims, and then eventually maybe get back to the arbitration. I'm sorry, to the civil case of PAGA. Anyway, so what this court did, the US Supreme Court said, interpreting California law, that's very important. They basically said, and it's now probably more complicated, I think, than the splitting of the atom. They essentially said that non-individual representative claims, which would be the part that couldn't be compelled to arbitration. The rest, the individual claims, can be compelled to arbitration. The non-individual representative claims that are sort of the remnants sitting around in court, said Justice Alito, who wrote the majority opinion, and this was, by the way, an 8-1 opinion, only Clarence Thomas dissented. He said, Alito, that and I've got the quote, my favorite quote from 2022, as for the non-individual representative claim pending in court, the correct course is to dismiss it. And everybody then promptly completely ignored that. And now the plaintiff's lawyers who love Justice Sotomayor, she wrote a sweetheart concurring opinion that the plaintiff's lawyers love, and it's the only thing they actually read in this opinion. And that basically says, well, gee, we shouldn't be interfering in California law, should we? And by the way, I'm sure the California legislature and the California courts, wink, wink, are probably going to interpret this differently. So maybe they should be doing that. And of course, that's what's actually happening. Arbitration, one way or the other, is important, but probably the most important thing that may be happening to PAGA in 2024, because this is already qualified for the ballot in November, is a complete reworking of the statute. And essentially what this will do is take these claims out of the hands of plaintiffs' lawyers. This is a classic example of claims and lawyers prosecuting those claims looking for clients and not the other way around. That is what happens in these cases. Oftentimes they have headless representative actions where they don't even have a representative. They're just seeking a representative who can assist prosecuting, the lawyer assisting in going forward. That will all change if the statute is radically reworked in November of next year. And essentially what this will do is it'll give these claims back to the state to prosecute and take the individual employees and their lawyers out of the process. So we'll see what happens. Espinoza versus Superior Court. This is a classic example of gotcha legislation in the arbitration setting. Again, as I said, California has been out to get arbitration for a very long time. There actually was a statute passed in California that Jerry Brown, second time I mentioned him, vetoed repeatedly, but that our current governor did sign shortly after he became governor. And what that did is it essentially made arbitration illegal in a very bizarre way in an effort to try to avoid arbitration being preempted, or sort of the anti-arbitration statute from being preempted by the Federal Arbitration Act. That was originally struck down by a U.S. District Court judge in the Eastern District of California. That went up to the Ninth Circuit, and in a 2-1 decision, the Ninth Circuit actually upheld the law and essentially made arbitration effectively illegal in California. That then changed, and the Ninth Circuit clawed the opinion back, found it to be inapplicable. They didn't apply it during the pendency of the Viking River case. Nobody understood why that was, because Viking River had nothing to do with that statute. And then after Viking River was decided in June of 2022, the Ninth Circuit said that they were going to rehear the case, and they voided the earlier opinion. The speculation is that one of the two judges who voted to uphold the original law and make arbitration illegal in California essentially changed his mind, and now is joining Judge Ikuda, who wrote a very, very, very spirited and very smart dissent. And if that's the case, in the Ninth Circuit, if that speculation is correct, the Ninth Circuit is going to strike down that law. What this little thing does is CCP section 1281.97. This says that if you don't, employer, because of course the employer has to pay 100% of the fees, if you don't pay the arbitration fees as required by the arbitration association, that whether it's JAMS or AAA or whoever it may be, and it's late, and you don't pay it within 30 days, you have basically breached the arbitration agreement, and you lose, you stupid employer, you lose your right to arbitrate. This is not a telephone call you as a defense lawyer will ever want to make to your client, because you'll probably get the notification. The client may or may not get the notification that it has to be paid. And if it isn't paid within that specified period of time, this is the gotcha of all gotchas. You will lose your right to arbitrate. And Andrew, on the 31st day, will be in court saying, hey, guess what, Judge? We're back. The other side breached the agreement. They failed to pay. Let's have a jury trial on this. So you don't ever want to be on that. So when you see that, be on the lookout. Make sure your staff, make sure your attorneys in your law firm, everybody you work with is watching out for that bill. Ask for the bill. Whatever you need to do, just make sure it gets paid on time, because you will lose your right to arbitrate. And one of these cases, I'm not sure which one of the two, I think it might have been Gallo. The judge, the Superior Court judge said, well, they kind of did it, and they tried, and it wasn't their fault, and it wasn't deliberate. And the Court of Appeals said, it doesn't matter. The statute says they got to pay it. They didn't pay it. They lose the right to arbitrate. So watch out.
Vaughn versus Tesla is a really interesting case that came out a couple of weeks ago. It stands for the proposition that if you're suing for an injunction under FEHA, that should be considered a public injunction. And under California law, you cannot be compelled to arbitrate a suit for a public injunction. And under the Federal Arbitration Act, as interpreted by Viking River Cruises, the FAA does not preempt this decision. So an important case if you're ever thinking of bringing a FEHA public injunction claim. Ramirez addressed the exact same issue in Patterson versus Superior Court that Tony and I talked about last year. This case, though, is more favorable to employees. First, this case holds that if there is a provision in an arbitration agreement providing for the party prevailing on a motion to compel arbitration to recover its attorney's fees and costs, that arbitration agreement is substantively unconscionable. And Ramirez also holds that a provision requiring each party to bear its own attorney's fees deprives an employee of his or her statutory right to recover attorney's fees if they prevail on the FEHA claim. Important to note, the California Supreme Court has granted review both in Patterson and Ramirez. Our next case, Navas, represents another arrow in the quiver of plaintiff employment attorneys to defeat arbitration. In this case, the employer moved to compel arbitration of the claims of 3 different employees. 2 of the plaintiffs, Martha Herrera Lopez and Benjamin Hernandez Ramos, opposed the motion, saying they did not recognize their signatures on the purported arbitration agreement. The employer argued that their denials or their not remembering signing the arbitration agreement should be disregarded because they weren't credible. The trial court found they were credible and held that the employer failed to properly authenticate their signature. The employer appealed. The Court of Appeal agreed with the plaintiffs, saying that the employer should not win on the motion to compel because there was no proper authentication. Other good cases for employees to plaintiff employment attorneys to cite are this Gamboa versus Northeast Community Clinic case, the Bannister case. Both plaintiff employment attorneys and defense employment attorneys will want to look at this brand new case called Irie versus Wise Auto Group, which came down about 10 days ago. This case holds that the I don't remember signing is going to still be an effective argument with respect to electronic signatures, but that it should not be an effective argument with respect to handwritten signatures on arbitration agreements. Immediately following this Irie decision, you can look at employment defense blogs and articles where they're starting to specifically recommend that all arbitration agreements should be signed in handwriting by the employees and not electronically. Now then, after addressing the signature authentication issue of the first 2 employees, Navas turned to the 3rd employee and looked at the procedural and substantive unconscionability argument that he had made. I'm not going to go into the detailed nature of that, but it's just issue spotting. If you have an arbitration agreement that you think should be voided for unconscionability, take a look at this case. Also, check out yesterday's decision in a case called Hernandez versus Meriden Management, 2023 Westlaw 1097324. This is a really interesting case. This holds that if you sign an arbitration agreement with employer A, and you're contending that employers B and C are your joint employers, and you haven't signed an arbitration agreement with them, and you decide to sue employers B and C and not A, employers B and C, even though they're the joint employer, they cannot use the arbitration agreement you signed to compel arbitration. Really interesting decision.
Zhang versus Superior Court. This is a really complicated case, but I think it's got a lot going for it, and especially if you've got one of these issues involving Labor Code Section 925, which was passed a few years ago, which essentially roughly makes a choice of law and choice of forum outside California unenforceable for employees at the employee's choice, and unless the employee is represented by counsel, so there's an exception for that. This involved a partner he was an equity partner at a law firm, and he had signed this arbitration agreement, and the question was whether or not, as an employee, if he had been one, he would be able to void the choice of non-California law. There was a New York law choice. And so one of the first questions, of course, is going to be, was he an employer? Was he not? And of course, for at least some partnerships, there's an argument that can be and has been made by certain equity partners that they actually are more like employees than they are owners of a business. And so it's a very complicated factual situation. But the net of this was that the court essentially said that there was a delegation clause here, and these things should be decided by the arbitrator and not the court, and that the arbitrator would have to make that determination as one of the preliminary decisions that came as a part of this, as the court put it, a clear and unmistakable delegation clause, which provided that issues of arbitrability would be decided by the arbitrator, and mandated that the arbitrator, not the court, must determine whether he was an employee such that he can invoke section 925. So this delegation, don't forget this delegation clause argument. That's Andrew earlier, there's a very important opinion that he wrote, or at least he wrote the majority opinion on.
We've lost your sound, Tony. Well, while
Can you
Tony,
can you hear me out? Can you hear me
yeah,
now?
we can. Yeah,
Okay.
yeah.
I don't know what happened.
I think that was God.
Anyway, so the delegation clause is very important in these arbitration agreements. So make sure that you have them. And all the cases that Andrew's been talking about in the last 10 to 15 minutes, those are just piled on top of the 150 or 170 some opinions that are out there, picking apart every single jot and tittle that you can find in an arbitration agreement. So it really is not for the faint of heart. Don't think you can just blindly go out there, draft an arbitration agreement, and assume it's not going to be attacked. It will be attacked, and it's very easy to find a case, really one way or the other, saying just about anything about arbitration.
Jot and tittle. There's a phrase no one's used since the 1700s. Our next case is
Scalia used to use it.
My point. For decades, when it's come to arbitration agreement, employers have had their cake and eaten it too. What do I mean by that? When an employee filed her lawsuit in court, the employer with an arbitration agreement would sit back and rub their hands together and salivate, waiting to see, is this judge going to be good for us or not? If the judge was good for the employer, the case would stay in court. If at any point the judge disappointed the employer would file a motion to compel arbitration. When the employee opposed it, citing waiver, the employer would say, no, you have to show prejudice. Where's the prejudice? And employees could generally never show prejudice. In this Morgan case, a unanimous decision authored by Justice Kagan, the Supreme Court said, no, there is absolutely no necessity to show prejudice whatsoever to make out a claim of waiver. One can only hope that the California Supreme Court gets the message and reverses its horrible, awful decision in a case called St. Agnes Medical Center versus Pacific Care, California, a 2003 case that has led to horrible, horrible decisions, such as last year's Quach versus California Commerce Club case, where the Court of Appeal reversed the denial of a motion to compel arbitration. The trial court had denied the motion, citing waiver, and the Court of Appeal said, no, there was no prejudice, even though the employer sat back for some 13 months litigating the case. And you know what? My wish may become true, because the California Supreme Court has granted review in the Quach case. As of December 27th of last year, the appeal was fully briefed. Amicus briefs are starting to pour in. The amazing California Employment Lawyers Association amicus brief was filed last week, as was an amicus brief by the Asian Americans Advancing Justice of Southern California, Thai Community Development Center, and Council on American Islamic Relations. Those amicus briefs were filed last week. We're just waiting for the Supreme Court to set a date for oral argument. Tony, do you want to make your usual comment at this point?
No, I think your comments will rise or fall on their own.
Well, I want you to. So Tony usually at this point says, no defense lawyers ever just sit back and wait to see if the judge is favorable, to which now I would have said, had he said that, check out this case from December, this Desert Regional Medical Center, Inc. versus Miller. In that case, the employer sat back for an astonishing 4 years before it asserted its right to arbitration.
Well, look, we could go on and on. Andrew, I think, actually did work at a defense firm at one point, and what actually happens, and he's cartoonishly interpreting to be some evil backhanded way of screwing an employee. I'm sure what actually happens is, in many instances, employers may forget that there was an applicable arbitration agreement. It may not get discovered at first, and there's not a good excuse for that, but that may in fact be the case.
For 4 years.
But I've never seen, certainly nobody I've ever heard of, and certainly nobody in my law firm I'm aware of, has ever said, we have an arbitration agreement, let's not assert it, let's wait to see how this judge does, and only then will we decide whether we're going to seek enforcement of the arbitration. Nobody in the real world does that. In the cartoonish world that Andrew lives in, they do. Let's move on. Okay, this is another very important series of developments associated with whistleblower claims, which have become very, very common these days. We see them with much greater regularity than I think we've ever seen them before in the past, and that's happened maybe since the pandemic. I don't know that it was related, but I would say probably one of three, one of maybe half of the claims we see now have some version of a whistleblower claim in it. And in this first case, this Lawson case, it's a perfect, Andrew.
Oh, sorry.
Jeez. All right. This is the Lawson versus PPG Architectural Finishes case, California Supreme Court case from last year. This is a good example, I think, of the perils of groupthink. Somebody somewhere along the line, some defense lawyer who apparently didn't have a copy of the labor code, made the argument that in order for a plaintiff to win in a 1102.5, which is the whistleblower statute, claim that employee would have to satisfy and go through the shifting burdens, familiar shifting burdens analysis from McDonnell Douglas, which essentially says that the employee must first make out a prima facie case, then the employer has the opportunity to provide evidence of a legitimate non-discriminatory business reason, or in this case, non-retaliatory business reason for the termination. And then the employee can say, no, it's all pretext. So that's how it typically works in the discrimination context. It's a test that Andrew hates. So somebody said, well, that sounds like a good test. It's got its own name. It's got 3 steps to it. Let's use that also in whistleblower cases. And seemingly everybody said, yeah, that's a great idea, including, oddly, plaintiffs' lawyers and also judges. Then someone finally came along and said, hey, you know what? There's this 1102.5. Why don't we open the book and see what it actually says? And when you do that, you find out that, lo and behold, there is a statutory framework complete with burdens of proof that have nothing to do with McDonnell Douglas, and in fact are quite contrary to McDonnell Douglas. And they basically say, and this is from the statute, the interpretation that came from the California Supreme Court, the plain text of the statute provides that the California previous application from the California courts of the McDonnell Douglas burden shifting standard is not applicable really in a 1102.5 claim. And really what you have to be applying is the one that happens to be in the statute, which is the far more employee friendly contributing factor standard. What is that? The contributing factor standard is, and it's expressly set forth in the statute, 1102.6, it enables whistleblowers to meet their burden by showing their whistleblowing activity was just one factor that contributed to the adverse action, even when there is evidence of other legitimate factors for the employer's decision. So as you can see, that's going to be a much more difficult defense burden if you apply that. Moreover, there's a heightened burden of proof by the employer, a clear and convincing standard and not preponderance of the evidence, which you would typically see in cases like this. Supreme Court then concluded with the following: to the extent PPG, the employer in the case, is concerned that the existing framework sets the plaintiff's bar too low by requiring only a showing that retaliation was a contributing factor in an adverse decision, PPG's remedies lie with the legislature that selected this standard, not with this court. Fat chance the legislature will ever do anything that's pro-employer in the state of California within our lifetimes. So it looks like we're stuck with this standard, employers. And like I say, it's amazing to me that it's taken so long for anybody to find it, because it's been sitting there in plain sight all along.
I think that actually this standard is also somewhere buried in FEHA. And if it's not, the legislature should immediately amend FEHA to incorporate this standard.
So that's what would be referred to as disinformation from Andrew, because he knows it's not in FEHA. By the way, FEHA wasn't renamed, was it? It's still, it's not the Civil Rights Act now. It's anyway, the Vadalero case. Now, all that doom and gloom I just told you about, forget about it for a second, because in this case, the prevailing party was the defendant. The actual test from the statute that I just talked about, which sounded quite bearish for employers, was applied, and yet the employer won summary judgment under that standard, under the correct standard, and that was affirmed on appeal by the Vadalero court. So the court said that the employer succeeded, showing that the alleged action would have occurred for legitimate independent reasons, even if the employee had not engaged in activities protected by section 1102.5. So this is where you want to be. Vadalero is your poll star. You want to go for this and make the defense, and certainly the summary judgment motion you file in one of these cases, line up as much as you can with this case.
Tony, can I ask you a question?
No.
Is the reason you keep saying the name of this case because when you say it, it reminds you of the Voltaire from your favorite movie, Twilight?
I have no idea what you're talking about, Andrew.
Okay, we'll move on.
I think the question was more revealing than my failure to answer, but go on.
All right, in our next case, this is another 1102.5 case. It also addresses Government Code Section 8547 and Health and Safety Code 1278.5. We're dealing here with a doctor who complains about patient safety issues. All of these laws protect those types of complaints. He files his lawsuit alleging that he was fired for complaining about patient safety issues. The trial court dismisses his case, finding that he failed to show pretext for the reasons given for his termination under the McDonnell-Douglas burden shifting test. The reason given for his termination was basically poor performance. It goes up on appeal. The Court of Appeal immediately reverses as to the 1102.5 claim, saying, hey, trial court, you decided this under the McDonnell-Douglas burden shifting test, not 1102.56, reversed. Then the Court of Appeal says, with respect to your Government Code Section 8547 claim, that should have also been analyzed under the 1102.6 framework. So that's reversed. Then, with respect to the Health and Safety Code Section 1278.5, the Court of Appeal says you did properly analyze that under the McDonnell-Douglas burden shifting test, trial court, but you got that wrong too. Dr. Scheer put on as his proof of pretext the fact that he had good performance reviews for 12 years. No one had ever advised him of any shortcomings in his performance up until he was fired, and that was enough to create pretext. Kilgore is another terrific 1102.5 case. So we have to go back to the statute to understand this case. 1102.5b provides in relevant part that an employee is protected from retaliation if she complains, quote, to a person with authority over the employee or another employee who has the authority to investigate, discover, or correct the violation or non-compliance, end quote. This case addresses how you interpret that language. While consulting on an environmental project for the Army, Aaron Kilgore believed that he was being told by the Army to do something illegal. and he complained about it. He complained both to his supervisor, who had no authority to do anything because the command was coming from the Army, and he complained to the very person from the Army who was giving him the what he believed to be the illegal advice. He sues, and the district court grants the company's motion for summary judgment, finding that because Kilgore's supervisor had no power to correct what he was complaining about, he didn't complain to the right person. The Court of Appeal disagreed with the district court's decision that his complaint was irrelevant under 1102.5b. The Ninth Circuit, applying something called the last antecedent rule, which I'm not smart enough to understand, but I'm sure Tony is. Under the last antecedent rule, that means you interpret 1102.5b such that an employee can complain to his or her supervisor, A, or she can complain to someone with authority to correct the violation, B, or she can complain to someone from the governmental agency. Here, Kilgore complained to both A, a supervisor, and C, someone of the governmental agency. Therefore, the 1102.5 claim should go forward.
The first disability and accommodation case, and we're going to talk about this quickly, that we have here is an Equal Pay Act claim, which was dismissed by the trial court, and that dismissal was reversed by the Court of Appeal. I think we wanted to highlight this just because there aren't that many cases interpreting the Equal Pay Act, certainly under California law, and this is one of them. And essentially what happened was the court looked at the evidence that had been supplied by the employer on summary judgment, which had to do with the salary ranges and the amounts that the female employee who was claiming that she was discriminated against, what she got when she had acceded to the same positions that another male employee had acceded to. That almost always then touches off the employer defense that the differentials can be explained by bona fide factors other than gender. And the employer in this case said, namely, the male employee's time with the company and his experience before taking both the positions that were at issue that the female employee was paid less in. But the court said that because the employer relied on evidence of its general practices to set salaries based on factors such as seniority and merit, it had failed to set forth this, quote, specific factors on which the male employee's base salary in either position was premised on the factors on which plaintiff's base salaries were premised. It is a little bit of a word salad there, and I think you really have to dig into this, but it's a very important ruling, primarily, as I said, because there are very few EPA cases under California law.
Our next case is one of the most kind of head-scratching, intriguing, important, and least discussed case of the year. In this case, an employee sued for discrimination and retaliation, and the trial court granted the employer's motion for summary judgment, finding that the employee had failed to establish a prima facie case of discrimination and/or retaliation, and if somehow she did, the employee then failed to show pretext. The employee, after losing on summary judgment, did something that I don't think I've ever seen an employee
and actually
do.
Didn't notice till I asked you about it over the weekend.
Wow, you just give away all the inside scoop. So the employee did not.
You were actually going to give me credit. I don't believe you were going to give me credit.
It's in my notes right here. So the employee did not appeal. The employee files a
Sorry,
motion.
so I interrupted. So this is important. So summary judgment granted in favor of the employer, and the employee does not appeal. Go ahead.
Why don't you just finish the
No,
case?
no, please.
The employee files a motion for a new trial. Now, something must have happened because this is just bizarre. The employee in her motion for a new trial says, look, using the McDonnell-Douglas burden shifting test is one way to survive here by establishing the prima facie case and then pretext, but I don't have to do that. The other thing I can do, and the employee cited this Light versus Department of Recreation's 14 Cal App 575, I can just also show that the weight of the evidence is enough to get me to trial. And the trial court agreed. The trial court said, yeah, you get a new trial, summary judgment reversed, or new trial motion granted. Goes up on appeal, and the Court of Appeal said, yeah, the evidence taken as a whole could support a reasoned inference of a retaliatory and a discriminatory animus. It's just a fascinating case.
Well, the thing that really caught my eye was, Andrew did the lead up, but the clutch here is that the Court of Appeal applies a abuse of discretion standard in reviewing a failure, rather in reviewing a motion that is granting a new trial. In other words, what the employee was able to do was avoid the de novo review standard, which is really no review deference at all given by the Court of Appeal in a summary judgment context, and slip into a much more pro-appellee, anti-appellant point of view with respect to a motion for new trial. Because what happened was the motion for new trial was granted, then the employer appealed, and once the employer appealed, it was subject to this very deferential standard of appeal. So we're talking in ways that only I think appellate lawyers can really appreciate. But the net was that the Court of Appeal did not review the dismissal de novo as they would have had it been a grant of summary judgment that was appealed from. It was a grant of a new trial that was appealed from. So I'm sure Andrew has now got his devious little hooks in this case and is going to be using it left, right, and center every time he loses a summary judgment motion, and I'm not sure he ever does. Price versus Victor Valley School District. I'm not gonna get into this case because we're getting a little bit short on time, but this had to do with a disability claim. It's probably the most recent California Court of Appeal on this. The takeaways that I think are important is that the court said that the employee actually does have the obligation with respect to the interactive process that the employee must make a reference to it so that the employer doesn't have to guess it if it's not obvious. So what the court said was the district was under no obligation to engage in the interactive process with the employee because her disability, resulting limitations, and necessary reasonable accommodations were not open and obvious. She denied having a disability or any limitations because she had been asked at one point, which meant that she had the initial burden to initiate the interactive process and request a reasonable accommodations. That's something that many employers, I think, are worried about in terms of whether they need to bring it up or whether the employee is going to bring it up. If they do bring it up, is the employee going to seek a disability accommodation? This is sort of an interesting footnote. I had a client recently that came to us and said that their DEIB department, B standing for belonging, had said that they wanted the company to ask all of their employees whether they had disabilities so that they could, and they had nothing but good intentions obviously behind this, so that they can, if needed, accommodate, but also make all employees, including disabled employees, feel welcome. And, I think there are some potential issues with that, just simply asking it if the employee hasn't disclosed it. But this case, what this does is it really makes the employer's obligation to engage in the interactive process only if the employee's got a disability that is not obvious, or as in this case, that is specifically not disclosed.
In our next case, in a 5-4 decision, the Supreme Court held that in enacting the Uniform Services Employment and Reemployment Rights Act, which basically says employers can't retaliate against people who serve in the U.S. Armed Forces, So they basically said that in public employers like Texas in this case can't discriminate against someone who serves in the Army. What's more astonishing to me is that Thomas, Alito, Gorsuch, and Barrett dissented, essentially because they believed that the states would have never entered into the nation but for them being able to fire people who opt to serve in the United States Army, Navy, and what would later become the Air Force. It's just kind of the dissent to me is just wild. All right, this is my next favorite case, but we're running short on time. So basically what this says, and this is an example along with some other cases that have already been decided and some new cases that are going to be decided, including one that's up for on review right now, this Groff versus DeJoy case, in which all the prognosticators are saying that the U.S. Supreme Court is going to raise the definition of undue hardship for accommodating religious beliefs and observances. Right now, it's really a de minimis test, and everyone thinks that they're going to raise this de minimis test up to the same level as an undue hardship under the ADA. But putting that aside, this shows how the religious judges on the U.S. Supreme Court are allowing people to use religion as a sword, not as a defense in the employment context. This coach, he prayed with his students in the locker room, on the field, and we have some photos just because, you know, the U.S. Supreme Court might not get it. He even called a press conference and prayed with his players. Parents,
by the way, these are photos that Andrew has on his iPhone that he himself took while on the field. Not praying, by the way, because Andrew hates God, but go on.
Although, well, so anyway, parents complained that their sons felt compelled to pray even though they didn't want to. The district takes action against him. He sues. He loses at the district court level. He loses at the Ninth Circuit. The Supreme Court reverses, finding that the school did not properly accommodate him by allowing him to engage in this sort of conduct. The dissent was really powerful, saying that, you know, the religious rights of the students and of their parents should have compelled the opposite outcome. But I think we're going to be looking forward to a ton more religious accommodation cases as the Supreme Court makes it much easier to sue for religious accommodation. All right, our next case. This is a case that if you're battling a motion for summary judgment, don't assume that the employer's articulated legitimate reason for the non-discriminatory or non-retaliatory action is sufficient. Too often when an employer says we should win on summary judgment because we fired the person for X reason and they can't show pretext, take a step back before buying into their argument. Check and see if what they're alleging really is a legitimate non-discriminatory reason. In this case, Dr. Vicky Mabry Haight applied for 2 vacant positions and she was never interviewed. And the employer gave it to 2 younger non-African-American candidates. She sues. The school district says she wasn't as qualified as the 2 people who got the positions. On appeal, the Court of Appeal says, no, that wasn't a legitimate non-discriminatory reason. She didn't have to even show pretext because the decision makers, when asked at deposition, why did you not interview her for either of those 2 positions? They said they didn't know. Shields. This is a great case that shows how the courts are just very hostile to employment disability cases. In this case, the plaintiff had a short-term disability, and the district court, relying on pre-ADA Amendment Act cases and pre-ADA Amendment Act regulations from the EEOC, granted summary judgment. The Ninth Circuit reverses, saying, come on, the ADA was amended. You got to look at the most current version of the ADA and the regulations implementing it, which allow for short-term impairments to be disabilities.
That's another example of read the statute, read the regulations. We're at the point now that we're almost at the end. We've got another 10 minutes or so, and we know you might be flagging. So we're going to.
Can I just jump in really quickly for one case that just came down, which Tony, you should love this case. This case is the Opara, OPARA versus Yellen case, 2023 Westlaw 1936-78. This is a horrible, horrible case for employees and an absolutely terrific case for employers if it says what the Ninth Circuit wrote. And I can't believe they actually meant it. The Ninth Circuit in this case says that if an employee has direct evidence of discrimination, they still have to go through the McDonnell-Douglas burden shifting test. That just is at odds with US Supreme Court precedent, with Ninth Circuit precedent. But if that's the law now, it's going to make it much, much tougher for employees to defeat a motion for summary judgment in the Ninth Circuit.
Well, you're right. I do love the case, and we're citing it everywhere and always right now. But and you as employer counsel should be doing the same thing. What the court did say is if the direct evidence is from the employee and is the employee's own source and it's not provided from any other source, meaning it's a declaration that Andrew or somebody representing the plaintiff has drafted, that alone should not be sufficient direct evidence to avoid the shifting burden analysis. That's what the court said, and it cites older cases, so it's nothing new.
It's quite new. It's
Okay.
horrible. Go.
All right, we're let's see. This is a workplace violence case. There is such a thing. And you can get a TRO as an employer on behalf of employees. The question here was whether or not the employee was entitled to cross-examine witnesses. So the court had a bench trial and didn't allow that to happen. The court said that it should have. So there you have it.
This is another workplace violence case, and it kind of proves no good deed goes unpunished for an employer. The employer gets a workplace restraining order, and the Court of Appeal reverses, finding even though this person who was threatening the employee may have ultimately been violent, not enough evidence was shown. I mean, it's just a nutty case. It seems like the Court of Appeal would need someone to bring an AK-47 into a bank or credit union and start shooting before a workplace violence restraining order could be granted. Just unbelievable.
Yeah, the alternative to that is obviously having the employee get a restraining order, just a plain old restraining order, which they can get under the CCP, and doing that instead of having the employer go in and getting a workplace violence TRO, which increasingly seems to be harder and harder to get. Trujillo versus City of Los Angeles. This was a case in which there was a summary judgment motion pending, and outstanding, it was within the 30 days, a 998 offer. And what the plaintiff's lawyer did, no doubt had it on his or her cell phone with an email already set to go. As soon as it was obvious during the hearing on the summary judgment motion that the plaintiff was going to lose, they dispatch an acceptance of the 998 offer to the defendant. And so then we had the question of, gee, can you do that? That's bold. And the Court of Appeal said no. It said that, and it affirmed the trial courts, the trial court agreed, that a dispute is resolved. Because a dispute is resolved and the outcome of the litigation becomes certain and known once a trial court issues its oral ruling granting summary judgment, that is the point in time at which both the text and purpose of Section 998 dictate that the pending Section 998 offer is no longer operative. So Andrew now is going to have to figure out something else to do with the 10 minutes before he goes up to the hearing to find out if he's won or lost the summary judgment motion.
And that, by the way,
as opposed to dictating or emailing a acceptance.
That's nowhere in the statute, but whatever.
Okay.
Do you want to do your math error case?
No, let's move on. I think we're past that, aren't we?
You want to do the FCRA case?
Yeah. So FCRA, I just want to talk about this quickly. And this is something that every employer who's doing background checks, you should immediately pause and say, can I do a background check? How do I do a background check? Should I have someone else do the background check? What if the background check is done incorrectly? These and about a million other questions you need to ask or when you're advising employer, need to have them answer, because this has become suddenly a very, very heavily regulated at both the state and federal level area of the law. And the FCRA, which is the federal statute, which actually is the most liberal in terms of what an employer can do or not do in connection with these background checks. And by the way, there are now state laws on all this. There has been for a long time here in California, and there are some city and county laws on some of this. This gets into the ban the box kinds of things as well in terms of getting background information about an applicant. What this case does is it looks at the question of what the willfulness standard is under the Federal Credit Reporting Act. And the employer argued that willfulness is, as it sounds, that was an intentional attempt to essentially violate the law. And the court said that, and this is a Ninth Circuit opinion, that willfulness under the FCRA requires the plaintiff to show that the defendant's conduct was intentional or reckless. Willful violations can lead to recovery of statutory damages ranging from $100 to $1,000 per violation, and they often are brought as class actions. So again, be very, very aware of this area of the law and read this case if and when you're advising on it.
Employers treat at-will employment provisions as though they're somehow a get-out-of-jail-free card, and they're not. In this case, the employee alleged that he was induced to move from Washington State to Northern California with promises that his employment would be long-term and that the employer had to have a lead project manager. He moves, he starts his job 4 or 5 months later when he's trained everyone on how to run the company with his lead project manager information. They fire him. He sues under Labor Code Section 970, alleging that they made material misrepresentations to induce him to move from one place to another. The employer cites the at-will employment agreement, which was integrated, saying you can't bring that. The Court of Appeal, with respect to the promises that they would offer him long-term employment, agreed and said you can't base a 970 claim on that because of the at-will employment. But with respect to the other promises surrounding the fact that they needed someone, they had to have this lead project manager, that was something that he could proceed on his claim. This next case deals with if you have an employee who works for an out-of-state employer. The out-of-state employer sues the employee in the home state, let's say Utah, for example. Then the employee were to sue in California. Under mandatory cross-complaint statutes of both other states and California, you would think that the employee's claims in California would have to be dismissed and he or she would have to bring them in the home state. This case says no, because California has a specific statute allowing those claims to go forward in California, and the full faith and credit clause of the United States Constitution does not dictate a different outcome.
This is let me just go back for a second. This is a good example of what happens when you're hiring across state lines, because every state, for the most part, has a different rule about these kinds of issues. And this involved California, as the graphic shows, California versus Utah, and the ways in which the various laws work in those two respective states. What almost always happens is each party will file in the jurisdiction that they think is going to be most hospitable to their claims, not surprisingly. And so we got into a lot. This is a great final exam, or I think even a state bar question about civil procedure overlapping with other substantive issues and having to do with constitutional issues of full faith and credit provisions, et cetera. But a lot is packed into that. Andrew, we've only got a couple minutes left. Why don't you fast forward to the Blue Mountain case, please?
God, I wanted to do Manuel, which if you're having an employer try to discover your employee's immigration status, look at this case. The next one, if you're dealing with an employer arguing that workers' comp has some sort of res judicata effect, it doesn't, look at this case. Okay, where's the case you want to
There's some
about?
puppies and kittens, and move on to Blue Mountain Enterprise, the next case. So the reason I like this case is that this is a sort of a out of central casting case about a covenant not to compete in the context of the sale of a business in California. Under section 16601 of the California Business and Professions Code, you actually can have a non-compete in the context of the sale of a business. And the question was whether or not, in this case, whether the owner who had sold the business could be enjoined from soliciting customers. And the court did uphold that and rejected the seller's argument that the non-solicitation covenant did not meet the requirements of 16601 because it was contained in his employment agreement and not in the explicit transfer of goodwill. So these things get to be really quite detailed in terms of, and there are cases that talk about this, where the actual non-compete language resides. Is it in the transaction documents or is it in the employment agreement? This court basically said that doesn't make that much difference as long as there is an explicit transfer of goodwill and those provisions are contained in either the employment agreement or in the transaction documents. All of this could easily be blown away, this law and laws like it, if the FTC actually does adopt what came out a couple of weeks ago, in which non-solicitation, non-compete provisions like this are endangered because the Biden administration, again, I think infringing upon what has traditionally been exclusively an area of state law, issuing federal directives under the FTC. That's beyond the scope of what we're talking about here today, but that's sitting out there, and there's a possibility that some version of that might ultimately become part of the federal law in the United States. That is the, I think, amount of time we had allotted, and those are all of the cases and statutes that are fit to print. We really appreciate your joining us here today. Thank you so much.
Thank you very much. We appreciate it.